conference. There are people that I need to thank that were responsible for bringing this off. First and foremost, the speakers in attendance who have flown in from all over the country and braved the first blast of the Cleveland winter. Thank you all for being here. And including our own Dean Enton, who will be speaking on one of the panels. Then we have the symposium faculty consisted of Dean Jesse Hill, Dean John Enton, Professor John Adler, and Professor Cassandra Robertson, who helped the students figure out what the panels should look like and helped them obtain the speakers. Then we have, of course, Nancy Pratt-Cantor and Ray Utrep, who are the admin officials who are out there making sure the conference runs well and have done all the logistics to bring all of our speakers in. In the back of the room, you see Tron Compton-Ingle and his staff who are ensuring that our technology runs smoothly and that this is webcast, so not only the 100 or so people here can watch it, but literally thousands of people will watch it live and in the months to come on YouTube. And then finally, the law review editors, who I assume are the nicely dressed people in the front row, for all their help in putting together a really, really terrific conference. The highlights of this group of speakers you're going to see, you've got some of the giants in the fields, and they've written countless articles and numerous books on the subject. They're going to give us some cutting-edge insights, which will make this very exciting. Some have spent time in academia, others in government agencies. All will come here with interesting and cutting-edge thoughts on this. Some of the speakers will focus on the historical interpretation of presidential power. Others will focus on areas in which executive power affects our day-to-day lives. This will be an opportunity to have a candid discussion about an exciting topic that touches on an enormous number of contemporary policy decisions. So without further ado, I welcome you to the conference, and I look forward to our first panel. Thank you.
Well, good morning. Welcome. I'm Jonathan Enton. I'm the academic dean. And as those of you who are from inside the school know, that means everything here is my fault except the weather. I don't take responsibility for that. We have a terrific opening panel here. The program describes the subject as the evolution of presidential interpretation. We have two really extraordinary scholars who have done groundbreaking work on presidential power, administrative law. Both have long and distinguished academic careers. Both have had important roles in public service. The details of their biographies are in the program materials, and I don't want to belabor those, but our speakers are Hal Bruff, who is the Nicholas Rosenbaum Professor at the University of Colorado Law School, and Peter Strauss, who is the Betts Professor at Columbia Law School. I will say that there is a local connection for both of these speakers, although I don't think either one of them has been in this building before. Hal Bruff has done a lot of very good work with the late Ernest Gellhorn. Ernie Gellhorn was our dean in the 1980s, and among the faculty he hired were Barbara Snyder, who is the president of the university now, and me, and I would just say every dean is entitled to one mistake. And Peter Strauss, as editor-in-chief of the Yale Law Journal, published one of the most notable law review articles in history. It's Charles Reich's The New Property, but the other article in that issue was written by my retired colleague Morris Shanker, who was a leading scholar in bankruptcy and commercial law. So unfortunately, Maury can't be here today to catch up. But we do have these local connections. I'm just going to turn things over to Hal and then to Peter, and we'll open things for discussion after they finish. So,
thank you, Jonathan. This one's for Ernie. And thank all of you for showing up, sliding in here, as did we, the panelists. I'm going to use my time to describe a forthcoming book I have. I have put some flyers for it out in the atrium. They will discount the price from astronomical to merely excessive. It's an academic press, what can I tell you? The book is called Untrodden Ground: How Presidents Interpret the Constitution. I wrote it because I knew that presidents are the single most important interpreters of the Constitution. I wanted to tell that story. I wanted to do it by reviewing U.S. history and inducting what I thought presidents had done, rather than deducting a theory from a template that consisted of things I knew just had to be true. There's been much too much of that in the academy in recent years, so I dredged all the way through and got to what you will read if you ever have the courage. The title, Untrodden Ground, comes from a letter Washington wrote after he'd been in office about 6 months. He said, "I stand on untrodden ground, and everything I do will be cast into precedent." Well, he was right, and what I write about is the precedents presidents have made over the last 200 years and some of our history. Yes, I talk about all 44, some more than others. So it's a story of presidential actions and the law that flows from them in a common law kind of way. The process basically is presidents do things. Obama's most recent Chinese agreement, for example. And then there's a feedback loop that I consider to be built of law, history, and political science, in which either Congress and the people ratify what the president has done, or they don't, and we have a new direction. I got this is not an idea original to me. More one reads, more one is embarrassed by one's capacity to make new ideas. I got it from John Locke and his ideas of executive prerogative, because I knew that if you steal a new idea, you're a thief. If you steal an old one, you're a scholar. So that's my claim. Presidential interpretation is really advantaged by the force of the power of initiative presidents have, and the president's new Chinese agreement is a good example of this. Presidents can do things that simply define the field of play on which other actors like Congress, the courts, and the people will respond, so they can paint the canvas cut. The process of presidential interpretation is self-interested, flexible, speedy, and dangerous. Things the process is not. I'm sorry, Justice Scalia, it's not originalist. Presidents aren't terribly interested, frankly, in what the founders thought at the convention, or even what some justices have said. They are very interested in what their predecessors have done. Those are the only other people in the world who have sat in that chair and suffered those pressures, and they look and listen to what their predecessors have done. It's also not originalist because presidents are operating a complex government in the modern day. They don't have the luxury to sit in chambers and ponder. And they start really with an overall view of the Constitution, a kind of a gestalt view of both the Constitution and the government it creates, and from that they move toward their interpretation of particular clauses. They don't start with clauses torn from context in the way litigation so often does. Secondly, another thing the process is, it is not strongly unitary in the sense of unitary executive theory. What presidents actually do when they supervise the executive branch is they focus on what I call the constitutional cabinet at the core of the executive. That's the departments of state, war, defense, we say these days, treasury, and justice. Those execute in a kind of unmediated way, as Peter and I will use the term, the president's constitutional powers over foreign policy, commander-in-chief, spending, and law. They also focus on controlling the military. And happily, so far in our republic's history, they have succeeded in doing so, although it has been close at times. One thinks of McClellan and MacArthur. After World War II, the military has pushed presidents toward military engagement until Vietnam, whereupon the military has started pulling presidents back from it. and supervision of the military has been a constant matter of stress for presidents in the modern age. And then finally, they try to control their own staff, and some presidents are more successful than others. If you think of the immediate advisors to the president in his own office, a few hundred people, depending on how you define it, that's plenty of people for someone to try to supervise. Those of us who have been deans of anything know that even a smaller number than that, for example, a faculty, presents its challenges. Presidents also acquiesce in the Senate's deep invasion through the confirmation power of presidential power to staff the executive branch. This is a feature of what Peter in his lovely paper refers to as reading Article 2 past the vesting clause. If you keep reading, you get to things like the confirmation power, which deeply qualifies how a president can run the executive. Presidents have also acquiesced in the existence of the independent agencies, including agencies like the Federal Reserve, right at the center of our economy and our government. There's an irony here, and I invite Peter to think about it and talk about it. We all will. Someone reading my book could plausibly conclude that presidents have too little power at the highest reaches of government to control the levers of executive implementation, but too much power, in the way Peter's paper describes, to supervise the regulatory elves who work in the basement. So maybe there's a disjoint here of an inverted sort, and I've been thinking about that since reading his paper. We can talk about it today. Another thing that presidential interpretation is not is really strongly exclusivist, in the sense that Dick Cheney would applaud, that someone like John Yoo would write about. Presidents ordinarily will abide statutes. They stretch them like crazy. That's the deal. Presidents have given up, for the most part, the authority to simply override a statute, Justice Jackson's Category 3, and they've claimed the twilight zone, where authority is unclear. They think that's just plenty. President Obama's directive to allow various undocumented young people to stay in the country is a good example of that, operating where there's neither clear authority for or against the action. This makes the executive order power quite flexible. It is, however, impermanent. It's always subject to what a successor may do. If you've tracked the progress of the abortion gag orders over 5 presidencies, you will find that it gets switched on and off like a binary switch, depending on the party the president comes from. And the executive order power is guarded by the of the president's veto, which is plenary. We can thank Andrew Jackson for that. He shifted the veto from a cautious constitutional constraint to a way for the president to veto a bill if he just thinks it's stupid. Okay, here's what the process is then. As it operates, I think it's a blend of the following things. Most important, the personal character and experience of the president. James Buchanan could not be a strong president. Abraham Lincoln could not be a weak one. Those character traits flow into interpretation. Secondly, the president's political values mixed in some complex way with the politics of the day. Third, the incentives that the job creates. The job certainly presses presidents toward a strong view of their powers because there is so much contending against whatever they want to do. Pity the Whigs. When they were presidents, they articulated a theory of very restrained presidential power. 2 things happened to them. First, they kept dying. And second, when they weren't doing that, they discovered that the incentives of the office suggested that something more vigorous might be good. Next, the weight of existing precedents. Presidential precedents, like limestone, accumulate over time, and we now have a pretty rich trove of them. The weight of those precedents is applied to what happens out there daily. I think of the tumultuous events of the year 2014. My book, maybe fortunately for me, largely stops at the end of 2013 when I sent in the manuscript. But think of what this calendar year has brought us that Obama has had to respond to. The British think of their Constitution in a beautifully British way as simply the sum of what happens. In a sense, I'm saying ours, as interpreted by presidents, is very like that. Barack Obama, before he became president, had a lovely little statement where he was talking about interpretation and said, it's a marathon in which the conventional tools of interpretation will take you through the first 25 miles. But said he, the last mile lies in the heart of the interpreter. I think that's true for judges. I think it's true for presidents. And what that means is the final mile really is a matter of judgment. And let us, oh, please hope, statesmanship. Outcomes. What has the process produced? I won't go through all of it. The book dredges one through at great length. One is, of course, we all know that presidential power has grown over the years. This is due to various things: the self-interest of the occupants to make it grow, the massive institutional advantages that a unitary presidency, single-person interpretation offers compared to a many-headed and reactive Congress. And then finally, modern conditions. The flow of modern conditions, a global economy, a thermonuclear and terrorist-infested world, all these things have made it grow. Yet I was struck as I wrote the book by the fact that presidential constitutional interpretation has in many ways been quite stable. Many fundamentals were in place by the time the founding generation exited the Oval Office in the year 1825 as James Monroe left. It falls into eras, that's one. Another one is that by the turn into the 20th century, presidents like T.R. Wilson start sounding quite modern in a lot of their analysis. You can see the modern presidency, at least in embryo, at that point. And then finally, and I think very interesting, an interesting point for what I'll talk about in a few minutes, is the nature of our post-World War II government settled into place pretty quickly. It was really there by not very far into Dwight Eisenhower's time. It's expanded since in some ways, but you can certainly see the bones of it. What we may have nowadays in the unmediated presidency that is pointed outward toward the world is what Elaine Scarry, an author that Peter has cited in his paper, calls a thermonuclear monarchy. Ooh. She says the choice is democracy or doom. Let's have a show of hands. Those who favor doom. I think we're all on the same side of this one, aren't we? It's how. That's the question. A couple of points. One, the line between the commander-in-chief power to take action without prior authority. I always tell students to turn those off. That's a gentle reminder to everybody in the room. Look at mine on. Okay. The line between presidential action, striking ISIS, for example, without prior authority, and situations where Congress has to say yes first, I think, and there's plenty of room for disagreement on this, I think that in the modern age, there is a rough constitutional settlement in place. I think it is a product of reaction to what Harry Truman did in Korea and to the nature of the War Powers Resolution. The Office of Legal Counsel and Justice, where many of us have had homes for a while, has been articulating this since about the Clinton time. It depends on the facts, The scale of an action, the risks to the nation that it involves, the duration that is anticipated. If it's a factual question, then it lies mostly in politics, and I think that's where it mostly should be. I think the 60-day clock for authorization in the War Powers Resolution is both constitutional and by and large beneficial because it tends to bring the branches together to negotiate out although that hasn't just happened with IS because we had this election thing that was going on. The major challenge now, I think, is the presence of a huge, secret national security bureaucracy. It wants to look out at us without us looking in at it. And the danger here at the foundation is the feedback loop for legitimacy that I first described depends on knowing what the president is doing. We can't ratify it if we don't know what it is. So the breach of that loop, I think, is the danger here. Controlling it may be the greatest constitutional problem of our time. Now, Peter will mention the fact that I conclude in the book that the presidential office now, quote, suffices to protect the nation and the rule of law. I think that is true. It is true at the level of constitutional interpretation. But much, I think, is in play and matters with incredible importance on the statutory side that I don't talk about in the book. Finally, a quick note or two about the mediated presidency, by which we mean the thick bureaucracies that do ordinary regulation, EPA, et cetera, et cetera. Here, the constitutional term most in question is faithful execution. The president shall take care that the laws be faithfully executed, often referred to as the core idea of the office, and I think that's not a bad characterization. My book talks about who it is that presidents want to benefit by executing the laws. It turns out they largely focus on benefiting their own supporting coalition. Very sadly, they do not support the powerless, with the sole exceptions, I think, of FDR and LBJ. They are not great friends of civil liberties. Security trumps liberty in the hands of presidents. And they are not, I'm sorry, Andrew Jackson, a tribune of the whole people. They pick and choose. For statutory empowerment of the bureaucracy, what Peter will be talking about, I would like to just mention what I call the Jacksonian settlement. That is this. There's a quote from William Wirt, the Attorney General, that Peter has in his paper that puts this in a nice capsule. During the controversy over removal of funds from the Bank of the United States, Jackson wanted the funds removed. His Treasury Secretary thought that would be illegal. He wouldn't do it. Now, Jackson did something quite un-Jacksonian. He didn't just yell at the man and tell him, if you won't do it, I will. Instead, they had an extended negotiation, and at the end of it, Jackson fired the Secretary of the Treasury and got himself Roger Taney, who was somebody who would do it. But to do this, he had to get Taney through the Senate. And the point is that the Jacksonian settlement says a president can urge a subordinate to take a particular position of law, can urge the subordinate with Jacksonian force, than which there is no greater force in presidential history, I would say. He was a mean old man. But he can't simply take the decision into his own hands, and even Andy Jackson thought that was true. I think it remains true today, and it's a primary control, because if the president fires the officer, well, it's noticed. Okay, so the feedback loop can happen there. For ordinary management of modern regulation, Peter describes it in his paper, is that from the time that I first looked at it empirically in the late 80s, when it was fairly new, it seems to have morphed from a process that really is one of consultation, negotiation, pressuring in the Jacksonian sense, into one of outright control, and outright control that's not visible. In that way, it violates a lovely phrase from my dear friend Peter Shane, who refers to the rule of law culture in the United States, which I trust all of us want to preserve. I'm afraid, Peter, that the rule of law culture may have been inverted from the rule of law to the law of rule, as in the law of rulers. Okay, we'll talk about that. I'm going to finish by reading the last paragraph of my book. because I want us to be hopeful for a moment before we descend during the day. This is very primitive PowerPoint. Here's the cover of the book. The flyer outside has it too. I love the picture. I'm going to describe it. Envision the best day in the history of the presidency. It is April 4th, 1865. Abraham Lincoln is walking down the street in ruined Richmond, holding the hand of his young son, a guard of soldiers trailing behind, and on all sides, freed slaves are joyously. He is just completing his redemption of promises of liberty and equality that this nation made not in the Constitution, but in the Declaration of Independence, and is bequeathing a new nation to us all. Hence, part of his legacy is a demonstration that not all presidential conceptions of the nation and its Constitution stand on equal footing. A president's highest attainment is, like Lincoln's, to transcend ordinary politics and to set the United States on a better course. Toward that horizon, there always lies untrodden ground. Thank you. We'll turn to Peter.
Well, while this is getting set up, I just want to say you've heard the advantages of sharing papers in advance of. You've heard the advantages of sharing papers in advance of a conference. I got Hal's book months ago. Spent much of the summer reading it and admiring it. You ought all to buy it. It's a wonderful account. He has been very kind to my paper, some of which you'll hear, but not by any means all. And the basic theme is the one that he stated, that so much depends on knowing what the president is doing. And our problem today is just there, and you'll hear later in the day from Heidi Kittrosser, who also has a book coming out from the University of Chicago Press, and for whom that is the principal theme. You'll hear me talk a bit about that as well. The Jacksonian settlement, I want to just embroider a little bit on Hal's mention of that. It wasn't just Duane. Duane was the second Secretary of Treasury that Jackson fired for refusing to undo the United States Bank. First one's named McFarland, I think.
Gifted him, yeah.
Yeah. Then when Tawney did the dirty, as he did, he was acting Secretary of Treasury. His nomination was the first nomination that the Senate of a cabinet officer that the United States Senate refused to confirm. The Senate passed a motion of censure of the president. When Jackson tried to put Tawney on the Supreme Court, a little bit later, you'll be surprised to learn the Senate turned that down too. You'll be surprised to learn that because you know he was Chief Justice. He wrote Dred Scott. Well, that was his second nomination after there had been a by-election in which Jacksonian forces took charge of the Senate. The motion of censure was withdrawn, and Jackson was confirmed as Chief Justice, and that gave Abe Lincoln his opening, unfortunately. So now to what I'd planned to say to you. Last week's New York Times characterized the election results as the final chapter in making the president small. Well, as a politician, maybe. But the results leave President Obama in just the position George Bush occupied following the by-election of 2006, and President Bush's actions in the following 2 years hardly suggest presidential shrinkage along the dimensions that we're talking about. My paper gives a bunch of examples here. I'll just mention one that Professor Kittrosser notes in her book. When his OIRA suppressed greenhouse gas rulemaking by simply refusing to receive the scientific analysis and regulatory proposals that EPA had developed after Massachusetts versus the EPA. The belief that President Bush had politicized agency decisions helped to fuel President Obama's successful first campaign. Restoring the integrity of government science was among his first promises to the American people. Yet the suppression of regulation in the service of political ends marked the run-up to his re-election in 2012 and maybe the recent by-elections as well. Professor Lisa Heinzerling has written corrosively about the manner in which politics carrying White House fingerprints derailed FDA scientific judgments about the safety of emergency contraceptives, and the meticulous work of a former GAO and CRS analyst has revealed unmistakable evidence of OIRA's political obstruction of numerous important health and safety regulations during 2011 and 2012, in the run-up to the re-election. Having now lost control of the Senate, President Obama, like President Bush, may be taking further steps towards control of government regulatory efforts. He seems to have been saying so. Some scholars have welcomed a tight presidential political control over regulatory outputs, either as a necessary implication of the Constitution's vesting all executive power in a singular president, or as an appropriate reaction to the exigencies of modern regulatory government. It's probably well enough known I'm not among them. Article 2 does not stop with the vesting clause, and it doesn't make the president personally responsible for law execution. It's only words about his relationship with executive departments that Article 1 contemplates Congress will create stand in sharp contrast to his power of command over the military. They say he may require the opinion in writing of the heads of those departments about how they anticipate exercising the duties that Congress has imposed on them. Right, here we are in the mediated presidency. He is to take care that they faithfully execute the laws. In Youngstown Sheet and Tube, the Solicitor General's argument had emphasized, as some contemporary scholars and judges do, the vesting clause. And Jackson's response is rather worth recounting. Lest I be thought to exaggerate, I quote the interpretation which his brief puts upon it. In our view, this clause constitutes a grant of all the executive powers of which the government is capable. If that be true, it's difficult to see why the forefathers bothered to add several specific items, including some trifling ones. And here he cited the opinion in writing clause. Having anything original to say in a paper about the president and the Constitution is a daunting prospect. It's in one sense a relief to be able to comment on these two striking books that the University of Chicago Press will soon be publishing. You've heard about Harold's. It builds on his lifetime of scholarship about separation of powers in general and the presidency in particular, and I think he's given you a good sense of it. And you really ought to be equally interested in Professor Kittrosser's Reclaiming Accountability, Transparency, Executive Power, and the U.S. Constitution. She's a younger scholar. You'll be hearing from her later on. Her work has focused on White House secrecy and its implications for presidential accountability. Her book examines both the presidential supremacy arguments grounded in those asserted needs for secrecy and today's arguments that the Constitution envisions a strong unitary executive, one empowered to take all executive decisions from the White House. But she argues power in a rule of law culture requires substantive accountability, ambition checking ambition, government actors ultimately answerable to the people. She and Professor Bruff and I don't at all disagree about this. And originalist arguments for presidential supremacy and the strong unitary executive overlook important elements of the framing that underscore this need. While acknowledging the changed circumstances of our national government and of its place in the world that have given these arguments such impetus, as well as the difficulties of effective response, she essays a careful exposition of counter-arguments that could help to restore actual accountability of executive government to the people. There's no doubt about the changes both these books build on, as many in this conference have noted before me. For me, they evoke another of the Youngstown opinions, Justice Frankfurter's. The accretion of dangerous power does not come in a day. It does come, however slowly, from the generative force of unchecked disregard of the restrictions that fence in even the most disinterested assertion of authority. What Professor Bruff has written helps us to understand how we got here. Professor Kitrosser, both the difficulties and the importance of working our way free. Professor Bruff's fundamental premise is that at the end of the day, presidents, as you've heard, rely on their own constitutional views, influenced but not driven by what their office has become before they came to it and by the advice they get from advisors, many of whom one also meets in the pages of his book. So the project is to see the Constitution through each president's eyes as an individual and profoundly influential reader of our founding document. Each has a personality, each acts within the politics and circumstances of his time, facing particular challenges from which the character of his presidency emerges, and by which the ground for his successor's action may be laid. He wants us to see not cyclical patterns, as other political scientists have done, Stephen Skowronek in particular, but change and over time growth as history and technology have brought us from tentative beginnings at the margin of the developed world to status as a military and economic superpower without even the slightest alteration of the few words by which the Constitution describes the president's authority and place in government. And as you've heard, that conclusion is an optimistic one, that overall the presidential office in the hands of its occupants has evolved in ways that seem sufficient to protect both the nation and the rule of law. He focuses on the bulk of his attention on foreign relations, on the unmediated presidency, where we might expect relatively little of law and have understood from the outset that other government actors are presidential alter egos, expressing or taking actions which reflect his views and decisions. The operative checks here are political, with, as Marbury versus Madison, sorry, that's not the right one, with, as Marbury versus Madison early expressed, few, if any, possibilities of judicial review. The Secretary of State in administering foreign affairs is to conform precisely to the will of the President. He's the mere organ by whom that will is communicated. The act of such an officer, as an officer, can never be examinable by the courts. Where the heads of departments are to act in cases in which the executive possesses a constitutional or legal discretion, nothing can be more perfectly clear than that their actions are only politically examinable. Presidential congressional struggles over this first actor presidency, the unmediated presidency, have lain at the heart of our president's consideration of their constitutional authority, as Hal told you. And it can be no surprise that issues of transparency and honesty in those struggles, the continuing accretion of presidential initiative respecting them, dominate his analysis. Concerned at the effect of our politics of one actor's unilateral control over an arsenal that is in itself sufficient to produce global destruction, Elaine Scarry, as he says, has recently inveighed against the thermonuclear monarchy, and he's more optimistic. The very fact of this responsibility and other actors' alter ego status warrants the personal focus his account brings, and the belief that, at least absent the cloak over the national security apparatus, there will be effective checks and counteractions. For this is the very reason why presidents concentrate on controlling the constitutional cabinet. Yet there is a mediated presidency, the world of domestic regulation, which is the principal focus of Professor Kitrosser's book. For many scholars of administrative law, including me, domestic regulation, and in particular the president's relation to agency rulemaking, have raised pressing questions, not just of discretion's exercise, but also of law. In the mediated presidency, government officials are not simply the mouthpiece of the president, conveying or carrying out his policy preferences. They are themselves the possessors of legislatively created duties requiring their exercise of significant elements of judgment. It could be thought significant in this respect that the opinion in writings clause, the sole statement about their relationship to the president, specifies a writing, not a conversation, potentially answering her accountability concerns. And for the decisions of the mediated presidency, it's just not so that, in Chief Justice Marshall's words, questions which are by the Constitution and laws submitted to the executive can never be made in this court. It's the ability of citizens to obtain judicial review, to assess the legality of actions adversely affecting them, that is the very coin by which the legislative creation of those duties, the duties of the mediated presidency, must be purchased. As Judge Harold Leventhal once trenchantly remarked, Congress has been willing to delegate its legislative powers broadly, and courts have upheld such delegations because there is judicial review. In this context, his optimism about the survival of the rule of law faces sterner challenges. Today's mediated presidency isn't and can't possibly be unitary in any personal sense. There have been several linked developments since Justice Jackson's formative experience that, in my judgment, underlie our changed expectations about the presidency. From an office dependent for success on persuasion of the bureaucracy it oversees, to an office that behaves as if it is responsible for and capable of control. So first, the executive office of the presidency has grown from a handful of officials that Congress tolerated on FDR's promise that they would merely advise him, to over 1,000 bureaucrats acting as intermediaries between president and agency, with czars who are responsible for major policy concerns, acting outside public administrative procedures, and shielded by White House prerogatives from public view. There are a lot of actors who are capable of claiming to speak for the president without being the president, and that is a bluff that, if you're outside the White House, is hard to call. Second, in the agencies themselves, the increasing politicization of positions and the practical effects, and the practical effects of creating the executive service, which happened during the Carter administration, have increased political control over high-level bureaucrats, undermining the civil service system and civil service expectations. Third, beginning in President Nixon's administration, rulemaking under new national health, safety, and environmental statutes augured major economic impacts and brought in its train presidential regimes of increasing control. And finally, and this is the one that seems to me least noticed in a way, the dawn of the information age has diminished, if it hasn't virtually eliminated, any agency advantage in its dealings with the White House that might come from superior access to information. A desktop computer tied to the government side of the new federal data management system puts instantly on White House desks the full range of information that is available to an agency. And if knowledge and information are power, the instant and independent availability of all this data on White House computer screens has affected a significant transfer of power to White House overseers, power that is, again, outside public administrative procedures and shielded by White House prerogatives from public view. And this, in my judgment, is where the major challenge lies to Professor Bruff's optimistic view that the presidential office, in the hands of its occupancy, has evolved in ways that seem sufficient to protect the rule of law. From his last remarks, I get the sense that he might not disagree. So now I want to turn for a bit to Professor Kitrosser's concern, finding effective means of assuring presidential accountability. Those of us who are worried about the steady and apparently irresistible growth of presidential administration will find in reclaiming accountability a thoughtful response to the overstatements of constitutional arguments that never seem to read past the vesting clause of Article 2. She understands the supremacists and the Unitarians well and thoroughly grounds her analysis of their arguments' flaws in original understandings. Rich with detail and examples, she shows how the Constitution neither presidential supremacy nor the stronger forms of argument for a unitary executive, but rather a presidency in which executive secrecy and command are contained and by law and accountable. The law whose faithful execution the president is obliged to assure assign duties. Here's Attorney General Witt's way of putting it. Assign duties to others than himself, and unless he's the absolute monarch, the authors of our Constitution clearly those assignments must be a part of the law for whose faithful execution he's responsible. Central to her concern is the secret curtain behind which the White House often acts, the cloak over its influence, whose cloak over its influence is the obstacle to accountability. The controls that OMB has long exercised over legislative requests, legislative testimony, reports, and speeches often figure in her analysis, but it's the emergency of agency rulemaking with high industrial stakes and in the hands of executive departments, relatively late in the growth of the regulatory state, that has brought so prominently into view of the president's relation to domestic regulation and his accountability for his influence over it. As recently as the middle of the 20th century, when federal regulation had blossomed and the Administrative Procedure Act was adopted, it was dominantly affected by adjudication. And it may have been that dominance that permitted Chief Justice, formerly President Taft, to breeze past the possible distinction between the unmediated and mediated presidencies in Myers versus the United States. I've got some excerpts from the relevant paragraph up on the screen behind me, and that's the foundation stone of so many unitary executive arguments. He's careful to remark in his opinion that in adjudication, presidential control over decision makers is constrained. The case gave him no occasion to think about agency rulemaking, and it has been in the context of rulemaking that arguments about the mediated have gained such significance. President Nixon successors have fashioned rulemaking supervision regimes of steadily increasing breadth and rigor, involving themselves in particular rulemakings of political significance to them as well. And one readily sees beneath the surface of these developments what then Professor, now Justice Kagan, persuasively detailed as a presidential view of constitutional authority that has shifted strongly into the first actor, unmediated mode. And one as readily sees the possibility, and in some cases the demonstrable fact, of the use of that authority for political duties, for political ends that are outside the duties and responsibilities that Congress has created for executive branch actors, uses, that is, that are outside the law. In the paper I use as an example Judge Wald's opinion in Sierra Club versus Castle, which approved an EPA rule requiring scrubbers on coal-fired utilities rather than their use exclusively of low-sulfur coal. EPA's decision was highly favorable to the coal miners of West Virginia, whose senator happened to be the majority leader of the Senate at the time. Had politics, presidential prodding, determined the EPA's decision? Judge Wald reasoned that a presidential role is both desirable to avoid agency tunnel vision, as it is, and constitutionally required, that what she described as undisclosed presidential prodding might have produced an outcome different from that which would have been reached without it was irrelevant to her function as long as the outcome actually reached was sustainable on the agency's record and reasoning. And she took 90 pages of Fed Second to show that it was sustainable. Early in her work, Professor Kitrossi remarks how unlikely it is that such judicial indifference to presidential prodding is going to change. Supreme Court justices owe their place to presidential appointment, and presidents may not be indifferent to their views about presidential authority. Justices aren't immune to the presidential mystique, and they are committed institutionally to avoid the casting of shadows onto a coordinate branch. Now, on the other side, a presidential awareness that courts aren't going to be concerned whether determinative prodding has occurred doubtless encourages that prodding. One looking at the dealings between Congress and the White House that produced first a presidentially managed budget, and then about 2 decades later, the Executive Office of the Presidency, might be struck by apparent White House willingness to trade promises of accountability for new political initiative. Indeed, more than 30 years ago, President Reagan worded his executive order on rulemaking review to respect agency autonomy and promise essential transparency about its exercise. And when Professor Bruff looked at that process about 25 years ago, he described Reagan's administration as a process of negotiation with trade-offs only at the margin, given the agency's massive advantage in the size and expertise of its staff. And that order explicitly acknowledged the superior force of statutory or judicial deadlines, and that a rule could be issued over the objections of OMB. Probably the most important feature was in the background, that its tasks were framed in the era of paper records. Rulemaking documents came in limited numbers of copies, and they lived in agency files, from which the White House could acquire them only with the agency's knowledge and only with relative difficulty. And how things have changed. The strongest arguments for a unitary executive have taken hold alongside the emergence of the age. Subsequent administrations have adopted regimes for influencing rulemaking that would leave no fingerprints, or that have simply failed to follow through on promises that timetables for review would be respected and that the changes review brought about would be placed in the public record. As I earlier noted, the growing breadth and use of computer data sources has eliminated much of agency's former informational advantage. For the public, this is transformative. Anyone who wants to see an agency's public data, including all comments previously filed, has it on her desktop, which permits in rulemaking a level of analysis and commentary that was never before possible. But there are additional elements of database accessible only within government, and they further expand the White House's access to the process, so that few now believe that White House rulemaking review remains a process dominated by agency responsibility and expertise, with trade-offs only at the margins. Professor Kittrosser flags transparency in mediated relationships as essential to restoring the president's substantial accountability to the people. And in this respect, she makes common cause with an important group of administrative law scholars, mostly women, who have been stressing both the present failures of transparency and the need for political influence to be openly expressed. Is there hope in last week's by-elections? What dealings might we now expect between the White House and Congress in the wake of those elections and in reaction to President Obama's "we can't wait"? Will we see legislation giving statutory form to the executive orders, and in doing so requiring and making enforceable the transparency that those orders have long promised? A Republican Congress might be strongly motivated to expose the tight control that presidential offices, rarely the president himself, now exercise over rulemaking outcomes. But this would hardly be a costless change. A complicating tension between our reliance on transparency to induce responsibility and oversight and our understanding that transparency chills candor. President Truman once wrote, "The president cannot function without advisors or without advice, written or oral, but just as soon as he's required to show what kind of advice he's had, who said what to him, or what kind of records he has, the advice received will be worthless." Congress to date has recognized these high stakes, at least so far as citizen access is concerned. The Freedom of Information Act reflects the proposition in two ways. First, by exempting the President and the White House offices from classification among agencies, and second, by exempting pre-decisional documents, long and properly understood to protect the confidentiality of policy advice. And if one needed confirmation of the wisdom of this exemption, one needs look only to the impact of a law from which it has been omitted, the Government in the Sunshine Act. This act, which is applicable only to the members of multi-member commissions like the FCC, requires the commissions to meet in public on a week's advance notice on all matters save those subject to limited exemptions, which do not include an exemption for pre-decisional discussion. a commission's decision of the budget request it's going to make to OMB and or the Congress for the coming year. Commission's discussion of possible rulemaking, these have to be held in public. The consequence of the act has been to lead agencies away from collegial discussion. Decisions are developed now and taken by circulating paper memoranda, by notational voting, and by other means that will avoid the necessity of an open meeting. Staff acquire effective political power that commissioners lose. So let me conclude. The presidency exemplifies a tension that animates all administrative law between the worlds of politics and the worlds of law. We can't have a government of laws and not of men, because at even the most basic level of individual bureaucrats, there will always be men as a part of it. Discretion can never be entirely subdued. The issue, rather, is assuring that we have a government of laws as well as men, that politics occurs within a framework respectful of legal constraint, that we're able to preserve what Peter Shane wisely described as a rule of law culture. And that in turn is that, and this again is in Peter's words, the written documents of law must be buttressed by a set of norms, conventional expectations, and routine behaviors that lead officials to behave as if they are accountable to the public interest and to legitimate sources of legal and political authority. There must be, that is, what I've characterized as a psychology of office, promoting the personal responsibility of those in whom Congress has created duties of administration, a psychology that might be reinforced both by the discipline of judicial oversight and by the possibilities of political oversight, not just from the White House, but also from Congress and ultimately from the people. And President Jackson wasn't alone in suffering politically from having fired two leading officials, members of his cabinet, before he could find a third acting official to do his will. You might remember the Saturday Night Massacre, which was essentially the same and had a pretty high cost for President Nixon. The servant acts in a different mindset than the independent contractor. The soldier in a different mindset than an attorney. Thank you.
Well, thank you both. We have some time for questions and discussion. Since there's already been some back and forth, let's open to the audience. If you do have questions, I encourage that. Because we are being webcast, let me request that you wait for the mic so that people who are listening from outside will be able to hear the question as well as the responses. So, Peter Shane.
So first, thank you for the repeated citation. That was lovely. It's great to be cited by people who one still regards as one's teachers.
You're not that young.
and yet younger. So I'm wondering what each of you makes of President Obama's recent public statement on net neutrality. This was interesting. This has nothing to do with the merits of net neutrality, but this is the only occasion I can remember, certainly in recent decades, where a president publicly stated his recommendation to an independent agency, implicitly conceding he has no proper role telling the agency what to do on the net neutrality policy, and taking the conspicuous risk, because Chairman Wheeler has not necessarily been on the same page in terms of policy, that the FCC might well decide not to adopt the policy that the president has embraced. I mean, in a way, this sort of reinforces the settlement that Hal was talking about, but it also seems to It's interesting, in the face of the Unitarians' claim that independent agencies are unconstitutional, this is a very conspicuous example of presidential acquiescence.
I thought so, and Peter, I think it was explicit at one point in the statement. I've seen parts of it. You know, it reminds me of the way that presidents deal with chairs of the Federal Reserve Board. They treat them like a foreign potentate. It's always true, and here Obama is doing it right out in public.
Two things to say, or maybe three. The first is that seems to me to be a political settlement, not a legal settlement. That is, it acknowledges that Congress, in creating independent regulatory commissions, has raised the cost of the authority that the Supreme Court has told us the president has over independent regulatory commissions. They are a part of the executive branch, right? That's Public Company Accounting Oversight Board, and as I've been saying that for a long time. They're obviously right about that. So what that means, it seems to me, if they're an executive department, I can't imagine why the president couldn't demand of Chairman Wheeler an opinion in writing about how you're going to exercise this duty, acknowledging that it's his duty, but you got to deal with me about it. Second, it's not the first time. It's at least the second time, because in an executive order that the president issued a year and a half or so ago, respecting the rulemaking review, he said repeatedly, independent regulatory commissions should follow this executive order. It's been the position, the correct position of the Office of Legal Counsel, so far as I'm concerned, ever since Reagan, that the word must could, with legal validity, be in there, and presidents have declined to put in must rather than should. Even should was kind of bold, because of the political price that they might have to pay in their dealings with Congress, but I think for no other reason than that. It's no clearer to me that presidents can tell the head of the EPA exactly what rule they must adopt on sulfur dioxide emissions or whatever, rather than advise with them about it. I mean, that gets back to the same question about where does the authority lie.
Thank you very much. I found both those discussions incredibly interesting.
Introduce yourself.
What do you say?
Introduce yourself.
I'm sorry. My name is David Rubenstein. I'm a professor at Washburn and came from Kansas to attend today simply because I'm so interested in these subjects. I think my question is for Professor Bruff, but certainly open for both of you. Harold, you talked about how what the presidents seem to care most about when they're interpreting the law is what prior presidents have done. And I'm wondering, to what extent did you uncover, or to what extent at how presidents consider what other presidents have not done as part of their interpretive exercise? It's not entirely clear that what presidents have not done is easily tracked. And if it's not easily tracked, I'm wondering if all that president is tracking what has been done, if the inevitable result will always be an increase in power and never the opposite. My second question, and you can one you do, but I think it's related, goes to trends in growth. It seems, I'm not sure I'd be able to prove this up, that all the other institutions of government have sort of ebbs and flows in the trajectory of the trends in their power. So Congress at times exercises more or less power, depending on if it's delegating more or less, depending on if it's gridlocked. The courts over history have, through justiciability doctrines, deference doctrines, and otherwise, either grown power or limited their power. But also the states, in some ways, we should think about as well, in terms of the contracting of their power in light of the growth of the federal government and preemption and all those things. And with respect to the presidency, in your studies, have you seen instances where presidential power has ever really ebbed and flowed, or is it a constant trajectory in the direction of growth? And if that's what you see, I'm wondering, obviously, what that means for separation of powers, but also what does that mean for federalism?
Thanks, David. On the first, you're absolutely correct that it's harder to look at roads not taken than roads taken, although there certainly are some clear examples. I'm fascinated by the fact that Lincoln's Emancipation Proclamation declined to free slaves in areas not in Confederate control. Secretary Chase asked him to do that. He said, I can't. I have no authority to free anybody except as a military command, and that has to be within areas in Confederate control. More broadly, presidents learn from rejected precedents. The most famous example would be the court packing plan. I'd like to see a little packing these days in various ways, but it's not going to happen. Some lessons get overlearned as precedents, I think, because of the political force with which they were delivered. For example, the rejection of the court packing plan. On the second, what I would say mostly is this, that from the constitutional standpoint, you do see, by and large, an overall increasing trajectory of power. However, there is also an increasing body of statutory control in both the mediated and unmediated presidency. Jack Goldsmith's work is quite good about this. In the terror presidency, he emphasizes that even the unmediated presidency is lawyered up to a fare-thee-well, with lawyers considering particular strikes against terrorists by drones and so on. So there is, just underneath constitutional level interpretation, a great deal of statutory command, and presidents ordinarily feel they have to abide that.
Let me add just one thing, echoing some remarks that I already made. Congress is in solitary control of the level of budget that gets presented to the president. Charles Black used to amuse his students at the Yale Law School by saying that if it chose to, it could reduce the White House staff to an appointment secretary. We are in a unique position at this point to see to what extent a Republican Congress will deal with a Democrat president to control his control over the rest of executive government, as it were. Whether it might be, my principal notion is that there might be this trade-off between exposure and you can keep your executive office, Mr. President, but one could imagine more dramatic steps simply in shrinking the budget of the executive office of the presidency. That was threatened to George Bush at one point, and as I recall, he said something like, well, that would be unconstitutional. You can't do that. He's wrong.
Yeah, Jeremy Bailey. I've got a question on Peter's last point, and it has to do with the Jacksonian settlement. And my understanding of the Whig view at that time was that Congress could issue directives to Secretary Duane, and Duane had to obey those directives and disobey the president. Would that be an option on the table for Congress today?
An explicit statutory command ordinarily has to be obeyed. That's the point of the Youngstown settlement, I think. And the secretaries involved regarded their statute as telling them that if the money was safe in the hands of the Bank of the United States, it had to be left there. The president disagreed. So it really was the question of reading the statute.
But it also is a question of reading the Constitution. If you were Professor Calabresi, whose views are perhaps not represented in the room today, you would take the view that that statute would be unconstitutional, that the vesting of the executive power in the president means that the president has the right to decide whatever Congress, constitutionally has the right to decide whatever Congress might want to say about it. Right? Not from my perspective, he fails to read past the vesting clause, but nonetheless, he and others have elaborately developed those views, and they've acquired a certain amount of currency in today's scholarly and other environments.
Wendy Wagner from University of Texas, although I just came across town, which was a about the same distance, I think, is fine. The presentations were great and really informative. And I want to, I think, go back to something that Hal may have mentioned early on. Just conceptually, in the mediated presidency, how should we think about the president's role? What is sort of the normative ideal that the president should play in a mediated presidency?
You know, I like more than Peter likely does some of the things that Elena Kagan applauds. I'm thinking of the youth smoking rule, but I'm going to also have to mention the Plan B controversy that you know so well. I like it when the president does what Obama did with net neutrality, gets up and says, here's my policy position. Americans and agency respond to this. That's what happened with the youth smoking rule. The danger there and in the Plan B controversy is that presidential intervention can cause illegality in two ways. It can drive an agency off its statute. That's what happened in youth smoking. Or it can drive an agency off the facts in the record and what the record supports. So that both of those are dangers that always surround presidential participation in the mediated presidency, because the president isn't necessarily listening to quite enough lawyering when the decision is made.
One of the characteristics of Professor Kagan's article, which I think is not sufficiently noticed, is that the presidential directives she was celebrating were directives not uttered under the cloak of secrecy. They were directives issued in public. And that's just fine, right? And that answers to the problem of accountability. In part of the paper that I mercifully omitted from the presentation this morning, I discuss the difference between two sections of the executive order over rulemaking. Section 4, which commands participation in a regulatory plan, and annually, and that including the independent regulatory commissions, right? In that instance, the president's willing to speak to the independent regulatory commissions. Every year, you have to provide me with what amounts to a regulatory budget. What are you going to be working on during the coming year? And that gets circulated, and that to some extent gets approved, and that becomes a public document. And there is the president engaging in the coordination and the priority setting and all the rest of that is inevitably and undisputably presidential business. And then there's Section 6. And Section 6 is the one that has gotten all the press, and Section 6 is the one where the cloak of secrecy has been pulled over what OIRA does, both informally and formally, and that, for me, is where the problems lie.
Well, we could, I think, go on for a good part of the rest of the day on these things, but this is the first session, and I feel some obligation to keep us reasonably close to schedule. We will take a break now and reconvene at 10:30. Thank you both for a terrific program.